All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good day, everyone. We are here for a special sitting with one case on our calendar. But before I call the case, I have a brief announcement. It turns out that this is also a special occasion. One of the judges on this panel is about to take early retirement next month. And after only half a century as a jurist, this is Judge Frank Q. Nebaker's final sitting, his concluding appearance on the bench. Judge Nebaker, allow me to state for the record that you have been an exemplary role model and a trailblazer for the many judges who have followed you on this court. There is no way we can thank you enough or honor you adequately for your unparalleled judicial service and the multitude of contributions you have made in your career to the court and the administration of justice. I'm sure I speak for everyone present and for all our judicial colleagues and the staff of this court in wishing you Godspeed and a fulfilling, well-earned retirement. After, of course, you make your contributions to this argument and this case. Thank you. Thank you, Judge Nebaker, and please don't be a stranger.
Thank you for this.
With that,
for the nice comments.
well, they're heartfelt. With that, we will proceed to hear argument in the case of Vernon Autry versus United States. I believe we have allotted 30 minutes in total to appellant and the amicus and 20 minutes to appellee. Counsel, you may proceed.
Good afternoon, Your Honors. Ann Keith Walton on behalf of appellant Vernon J. Autry. Of our total 30 minutes, we have split our time, and so I will be speaking for 15 minutes, and I would like to reserve 2 of those minutes for rebuttal. May it please the court. Mr. Autry respectfully requests that this court reverse and remand the trial court's order denying his motion for compassionate release. The trial court erred in several ways. In a broader sense, the trial court errs by finding the receipt of the COVID-19 vaccine defeats an incarcerated person's otherwise extraordinary and compelling reasons for compassionate release. Those reasons being his medical conditions that place him at heightened risk of severe illness and death from COVID-19. Looking specifically at Mr. Autry's case, the trial court erroneously found that, quote, no information has been provided to the court that Mr. Autry remains at high risk, even though he has been vaccinated. This finding also reveals that the trial court failed to apply the preponderance of the evidence standard. Mr. Autry suffers from severe obesity, type 2 diabetes, asthma, hyperlipidemia, and hypertension. In his pleadings before the trial court, Mr. Autry presented ample evidence that these conditions put him at higher risk during the pandemic.
Higher risk as compared to who? As compared to, do we know if that puts him at a higher risk as compared to somebody without any of those conditions? Now that he's vaccinated, if he's at a higher risk as somebody without any of those conditions who's unvaccinated? What's the point of comparison when we determine whether or not he's at a higher risk?
Yes, that's an interesting question, Your Honor. I believe that we're focusing on the fact that he's incarcerated. So that places him at higher risk than the general population. And also his medical conditions place him at higher risk than a person without those medical conditions. And Mr. Autry argues that even having been vaccinated, the evidence before the trial court was that his medical conditions still put him at a higher risk of severe illness.
May I ask you a question about that? Did any witness on behalf of Mr. Autry testify about the significance of his vaccination?
There was no evidentiary hearing held in Mr. Autry's case, but there was an affidavit submitted by a certified legal nurse consultant. She did attest to the fact that Mr. Autry's medical conditions place him at higher risk of severe COVID. And
Did she speak to whether and to what extent that was true now that he's been vaccinated?
She did not include in her affidavit anything about the vaccination, but her affidavit was submitted after Mr. Autry had been vaccinated.
Why do you say that incarceration makes a greater risk to the prisoner rather than to be out publicly on the streets or wherever he may live? What makes it more likely to be a higher risk environment when he's in prison?
Your Honor, starting with the beginning of this pandemic, I believe the DC Council and public health experts specifically identified incarcerated people as being at higher risk for a variety of reasons.
That was then, now is now.
Yes, and the CDC still identifies incarcerated people as being at higher risk or needing a booster shot. They have specifically identified people incarcerated as needing the booster shot. So incarcerated people are still identified as people who are at higher risk.
So if we take that as a given, that the prison population is particularly vulnerable, likely to contract COVID, likely to suffer worse outcomes if they get it, how do we factor that into 24403.04, where it refers the entire universe of people who would be considered under the statutory provision are prisoners? That's everybody, I think. I mean, and I could be wrong. Maybe this applies also to people who are out and under, supervised release. I'm not sure. But it's talking about extraordinary circumstances as to the prison population. So factoring in the fact that they're in prison seems to me a little bit at odds with the statute. That would seem to be baked in, and you need to show extraordinary beyond being in prison.
Right. So, does Your Honor have a specific question? Or
I guess the question you are saying we should take into account as part of the extraordinary and compelling circumstances that he's in prison. My reaction to that is that's already baked into the statute. That can't factor into the extraordinary and compelling circumstances because the statute assumes that somebody is in prison. And so you need to show something more than that, and the fact that they're in prison doesn't factor in under the statute. You're saying the opposite, and I would just like to understand why.
Okay, so going to Mr. Autry's specific case, he presented a plethora of information about his specific medical conditions, and it really comes down to these medical conditions. We can talk all day long about the vaccine, but one thing doesn't change is that Mr. Autry has 5 medical conditions, at least some of which place him at higher risk of severe illness or death from COVID-19.
Does any higher risk get you to where you want to go? I mean, suppose it's the case that an unvaccinated person is placed by virtue of those pre-existing conditions at a very high risk, but a vaccinated person is now at a very low risk. It might still be a higher risk than a person without those conditions, but maybe it's only 1% higher or what have you. See, I'm just wondering, what do we really know about the effect of vaccinations on prisoners and on prisoners with the sorts of conditions, the serious medical conditions, such as Mr. Autry has? If the vaccination basically makes prisoners like people who are outside prisons or very close to it, would we still say that there's an extraordinary and compelling reason to release those prisoners? Do you think that comparison is relevant?
Yes, Your Honor, but I also believe that it comes down to specific medical conditions, because we can either talk in a general sense or we can talk about the evidence before the trial court in Mr. Autry's case. And the evidence before the trial court in Mr. Autry's case was that his medical conditions do increase his risks.
Well, that's one piece of the evidence. I don't think we disagree with that proposition. But there's another factor here. There's another piece of evidence, namely he's been vaccinated. People work very hard. They developed this shield to protect people from COVID-19. And there seems to be indication that it protects people like Mr. Autry too. Don't you think that's relevant?
Your Honor, I believe it is relevant. We do have to look at the information we have about the vaccine that was presented to the trial court. And here in the government's motion before the trial court, they pointed to, I think, 2 or 3 links to the CDC's webpage with the general propositions about the vaccine's efficacy and pointing to a clinical study that found that the vaccine was 95% effective in preventing COVID-19. That was from a clinical trial. That has been quoted many times. It's quoted by the government, it's quoted by the trial court here, it's quoted by in all of these cases. But however, if you look at the clinical trial data, only 10% of the tested population was African American, only 35% was obese, just 8% were diabetic, none of them were incarcerated. So really, this data that everyone submits based on the vaccine does not directly apply to a person's particular medical conditions. 95% of the general population without these medical conditions. How can we say that that means that Mr. Autry isn't at heightened risk?
Who's got the burden on the evidentiary questions to the extent there are gaps in the record and we're not really sure where does the burden lie?
Mr. Autry has the burden to prove his eligibility by a preponderance of the evidence, of course. And to that I say, in this case, Mr. Autry presented a lot of evidence. He presented the affidavit, he presented information about his particular medical conditions. He presented information from the CDC. He presented information about variants. He countered the government's proposition that the vaccine protected him with evidence of variants. The CDC had already identified the variants and was expressing concern. The government put forth about 3 pages of information with general information from the CDC about the vaccine. This information did not address Mr. Autry's specific medical conditions. The government presented absolutely no evidence that a person who's incarcerated with Mr. Autry's 5 specific medical conditions would no longer be at heightened risk of severe illness. So if we're looking at the evidence before the trial court in this case, Mr. Autry proved by a preponderance of the evidence that he's at heightened risk and that he is eligible for compassionate release under the extraordinary and compelling reasons provision of the statute.
If released, would he be less risk?
Would he be at less risk if he was released?
Yes.
Well, I believe he would still be at a heightened risk as to the general population.
So, where does that take us?
That's a good question, Your Honor. I believe, though, that we're looking at a person's heightened risk. The council was concerned with incarcerated people, and that incarcerated people would be at higher risk in prisons than people are at risk out in the community. And so they were really looking at the medical conditions of the prisoner and whether they presented a higher risk of severe illness or death. Would he have less risk out in the community? I don't know. I don't think that can be totally answered. It depends on a variety of circumstances. We don't know if Mr. Autry has, for example, received the booster shot in prison. It's been 10 months, 11 months since the trial court decided this case. Since then, there's been the Delta variant. There's been the booster shot has been authorized and recommended specifically to people in prison. And there's no evidence that Mr. Autry has received the booster shot. So Mr. Autry does still remain at higher risk in prison. Perhaps if he was released into the community, He could take more efforts to keep himself safe. He could choose to get the booster shot, go get it. And he wouldn't be subject to, for example, the Texas prison, who had a terrible outbreak of Delta. And a lot of people who are vaccinated ended up getting the vaccine, and I believe one died.
He couldn't get a booster shot in prison.
Mr. Autry, to my knowledge, has not had the booster shot.
He could not get one in prison.
I'm not sure, Your Honor, because I don't have any particular information about when the booster shot will become available to Mr. Autry. But in the community, he probably could have gone out to get the booster shot a while ago. So yes, he does remain at higher risk.
Well, I think the FDC, the FDA announced today that they were approving booster shots for all adults. So, I mean, it seems like booster shots are available for prisoners too.
But that's the problem, is that it seems like, we keep saying it seems like, or maybe, or we hope the vaccine eradicates this thing, but we're still very much in the pandemic. There's still so much we don't know. Even on
Well, I guess there are two questions that we have to ask. One is whether evidence that a prisoner has been vaccinated and the value, the benefits of that vaccination is relevant for the trial court to consider in one of these motions. A question that is perhaps already answered by our decision in Page. The other question is whether in this particular case, the judge could fairly find that Mr. Autry did not meet his burden of proof because he hasn't really established that the vaccination did not materially change the calculus. Is that a fair summary of where we are in these cases?
Yes.
All right, let us do this. We're a little bit into your rebuttal time, which we'll give you, and we'll be sure to give it to you. Let us hear from amicus counsel. Mr. Maneri.
Thank you, Your Honor. May it please the court, Paul Maneri on behalf of the Public Defender Service. As amicus in this case, I will be focusing on the general interpretation of the compassionate release statute as it relates to COVID-19. I defer to Ms. Walton on how the statute applies specifically to this case. I'd like to reserve 3 minutes of my time for rebuttal.
Do you plan in discussing the statute to discuss what the term acute vulnerability means?
I do. I can address that now. It's not where I was planning on starting. I think
it's something I've been wondering about, and so I'd like to hear what you have to say.
Sure. I mean, I'll be the first to say that acute vulnerability is not clearly spelled out in the statute. I think in light of the legislative history, it's best understood as heightened or increased vulnerability. That is how the council refers to other extraordinary and compelling reasons when it's talking about COVID-19 in its committee report.
And when I think, and when you say vulnerability,
yeah,
how do you interpret that term? If you're interpreting acute as heightened or increased, I'm not sure that's the medical usage, but that's okay.
I think vulnerability has to mean that someone is exposed to harm, they are left vulnerable, right? That doesn't mean that their risk of harm is certain or even probable. It means that they are vulnerable to harm. And so, of course, that's modified by the word acute. And again, legislative history suggests that acute is synonymous with heightened or increased in this context. But I think
I asked you the question because my thought process has run something like this. The term acute vulnerability would seem to refer to the degree or the high degree of risk that because of a serious pre-existing medical condition, the prisoner will sustain a severe complication due to COVID-19. In other words, the legislature, in saying, look, every prisoner can get COVID-19 and every prisoner can suffer severe complications from it, but some are at greater risk than others. The ones we know who are at greater risk than others, and the ones who therefore may have a better shot at showing a extraordinary and compelling reason to modify their sentence, are those with certain serious pre-existing conditions, medical conditions. And if that's the sort of thought process, then something like a vaccination that reduces that risk, that in effect says to the person, well, you have this pre-existing serious condition, but the risk that this condition will cause, in the word of the statute, cause you to sustain severe complications from COVID-19 is substantially reduced. Well, that seems very relevant given the philosophy behind focusing on the question of acute vulnerability in the first place. That's the direction of my thinking. So I'm thinking that if a prisoner comes to court and says, well, I have this acute vulnerability, it's very relevant to say, well, but you've been vaccinated. And all the statistics we have, I grant you they're incomplete. All the statistics we have indicate that your risk has been reduced and reduced substantially. Do you think that reasoning process, put aside whether the evidence in this case calls for a remand or calls for further exploration or whatever, do you think that that reasoning process is a correct way of looking at it?
Yes. And let me just back up a little bit and say, I think more generally what our position in this case is after Page. I think after Page, your reasoning is correct that a vaccination is a relevant factor that a court can consider when determining whether someone's risk from COVID-19 is extraordinary and compelling. But I think under Page says that when deciding whether that risk is extraordinary and compelling, a trial court must exercise appropriate discretion to review the compelling facts of a case and must consider any reasonable factor that directly impacts on the determination of whether an applicant is at risk of severe illness. So I think the lesson from Page is that vaccines are relevant. They are one relevant factor, but they are not the only relevant factor, right? We know now, and we're understanding better every day as scientific research progresses, that some vaccinated people remain more vulnerable than others, even after they've been vaccinated. Things like age, medical conditions, waning immunity, whether they live in a congregate setting, the new variants, the possibility of long COVID, all of these are factors that bear on a person's risk of developing severe medical complications due to COVID, even after somebody's been vaccinated. And we also understand that the stakes remain high after someone has been vaccinated. I mean, in DC alone, since August, there have been 49 fully vaccinated people who've been hospitalized and 10 fully vaccinated people who have died. One person in the Bureau of Prisons custody, as far as we know, has died after being fully vaccinated. His name was Rashim Hicks. He was 42 years old. So I think it's quite clear that vaccination is not the only factor when we're talking about predicting risk of severe medical condition, severe medical complications due to COVID. And that's our position. That's why we think that the court ought to reject the government's invitation to adopt a rule whereby vaccinated people cannot get compassionate release unless they are immunocompromised. That's what I understand the government to be arguing, and our position really is that that's not the right rule in this case.
Can I ask, do you think, I know you started this argument by kind of ceding to Ms. Walton the interests of her client and staking out sort of a broader, more systemic view of how the statute should be interpreted. Assuming I agree with everything you just said about how the statute should be interpreted, do you have a view on whether or not the trial court in this case ran afoul of that understanding? I mean, the trial court here did not seem to, so far as I can tell, adopt a bright line rule that you're vaccinated, that's it, you're outside the bounds of the statute. It seemed to voice a more evidentiary concern that based on what we know, there's just no evidence here that can lead me to believe, given the vaccination, he's still at an increased risk. We just don't have that evidence. So back to the question, do you think the trial court's ruling here runs afoul of the rule that you're proposing?
I do, because I think that the rule that we're proposing is that this court has to make clear to trial courts that vaccination is one factor, it's not the only factor. And so it was error for the trial court in this case to not consider that affidavit that Ms. Walton was talking about, that was submitted after Mr. Autry had been vaccinated and talked about his increased risk. So that is my view on how to resolve the record in this case. And then, as I said, my bigger point, my main emphasis is that going forward, the rule that this court announces about how to deal with vaccination is what, as amicus, we're sort of most interested in, and what we think is the most important. Obviously, Mr. Autry's health is of paramount importance. But like I said, that's for Ms. Walton to talk about.
Having said that, what do you want us to do? What remedy do you want us to supply?
I think it would be appropriate. It's consistent with our view as amicus about how to interpret the statute to say that the trial court erred by not considering post-vaccination risk as put forth by that affidavit, and to remand for further consideration.
So just pinpoint this for me. So I'm looking at the trial court's order, where its bottom line as I read it is no information has been provided to the court that Mr. Autry remains at high risk even though he has been vaccinated. If we were to direct the trial court back to the affidavit that you're highlighting, is there a point in that affidavit that you think contradicts what the trial court says, that there's no information that he remains at heightened risk? And is there a point you want to highlight for me?
I mean, again, I would defer to Ms. Walton on that point. I don't have anything specific in there, but I do think that the fact that the court is making such a sweeping pronouncement about there's no information and it doesn't even mention that affidavit, that's what I would say about this record.
Are you aware of any data, reputable data, comparing vaccinated prisoners to vaccinated persons in the community?
Not
on the issues we care about, vulnerability to
right.
and so forth.
I'm not aware on a large scale. Obviously, the two studies that I pointed the court to in the 28K letter that was submitted on November 9th indicate that fully vaccinated prisoners are still at very high risk. I mean, I think the BOP facility—
I'm not sure you're right about that, actually. Though I think for example, the Texas prison data that you referred to show that it makes us shows something like forget the exact numbers now, but it's something like a 90% decrease in the risk to vaccinated prisoners from COVID-19, of serious harm from COVID-19. I mean, no vaccine is going to be 100% protective of everyone. And I take it nobody's arguing that only a vaccine that is 100% protective would be sufficient to deny a prisoner's request under this statute. Do you know of any data that exists as to the protection that vaccines provide to persons with what we've referred to as serious medical conditions, or to persons with the particular medical conditions that Mr. Autry's medical profile shows? I'm not aware of that, but maybe you are.
I'm not aware. I'm sorry, I didn't mean to interrupt.
No, go ahead.
I don't believe that the CDC collects or reports on that data, which is sort of part of the problem here, is the uncertainty about who remains at risk after vaccination. But what I can tell the court is that in the course of preparing for this oral argument, there is an emerging scientific consensus. If you look beyond the CDC, obviously the CDC develops its recommendations based on cutting edge scientific research. And in the past couple of weeks and months, there is an emerging scientific consensus that the same medical conditions that the CDC has been advising increased people's risk for severe illness or death from COVID, those are the medical conditions that the CDC is now worried about are increasing the risk of breakthrough infections and increasing the risk of severe illness or death from breakthrough infections. And
Right. That's very plausible. And the question is, it doesn't tell us, or the concern is to say that doesn't tell us enough unless we can quantify it in some meaningful way.
I'm not sure that the statute requires a precise numerical risk, Your Honor, in order to say that the risk is extraordinary and compelling. I mean, I think you look at subsection A3B3, which is the only subsection of the statute that specifically references COVID-19 vulnerability. The language that precedes acute vulnerability to severe medical complications is that if a person suffers from a chronic or serious medical condition relating to the aging process, forget about COVID. That's an extraordinary and compelling reason if they meet the other requirements of that subsection. And so I think that's really a very interesting aspect of the statute. It basically says that when it talks about COVID, people with three conditions, people who meet three conditions, of which the heightened vulnerability to serious harm from COVID-19 is only one, will be deemed extraordinary, will deem to have extraordinary and compelling reason to have their sentence modified. The other two conditions being that they be over 60 years of age and that they've served a certain period of time of their sentence. The implication of that is that if all you've got is the COVID-related condition, that's not enough. In other words, if you're talking about somebody who is under 60 or who hasn't served the requisite degree of time, that is not enough as a general proposition to show extraordinary and compelling reasons. Respectfully, Your Honor, I disagree that that's the implication. I mean, I think we can look to the committee report on pages 27 and 28, where the council specifically says that the trial courts have exercised appropriate discretion in saying that people who do not meet those age and length of incarceration requirements, but whose age or medical circumstances or other factors increase their vulnerability to COVID, nevertheless may meet that other extraordinary and compelling reasons.
Well, that's consistent with what I'm positing. I mean, the statute says if you have A, B, and C, then you've shown an extraordinary and compelling reason. Well, the implication is that if you don't have all three of those things, if you have less, then you haven't shown it. Now, you may still be able, in the totality of circumstances, to show extraordinary and compelling reason to modify your sentence. And I think the council, in its legislative history, recognized that. But for all they said, they didn't change the language of the statute. And all I'm saying is that the direction of the statute is to say, if you're going to rely on suffering from a chronic or serious medical condition, not related to the aging process, that causes an acute vulnerability to severe medical complications from COVID-19, you better have something else as well, or something in addition to that, or something unusually, with an unusually high risk, or something that amplifies that, because the way they've written the statute, that alone doesn't seem to be enough.
Your Honor, I see what you're saying. A couple of points in response. I don't think it is, as a textual matter, the case that the statute implies that if you don't meet those conditions, you presumptively don't get release. The text is very clear that these are enumerated examples meant to guide a trial court's discretion, that they're not the only categories for relief that a person needs to meet. That's clear from the text, from the word including.
Yes.
That's clear from the word other extraordinary and compelling reasons, which refers back to subsections A1 and A2. And it's clear from the legislative history, where the council says as much, that they are satisfied with the interpretation that trial courts have put on the statute, which was a much broader, much more expansive definition of other extraordinary and compelling reasons than what you'll find in the text. So I think as a textual matter, as a matter of legislative intent, it's quite clear that the council was thinking about risk that is not specifically the risk that they outlined in the text. That's meant to be a guiding principle. And I think, again, the main point that I want to emphasize here is that whatever the standard is, and I agree it's not an easy standard to define, but whatever the standard is, vaccination cannot be the only factor that a trial court considers when determining whether that standard has been met. We've talked about the evolving scientific and medical uncertainty and how that has to play a part, and how trial courts have to be able to consider the most updated factual information and the information that distinguishes risk between people. But what we haven't talked about is the fact that the council, as we note in our briefs, passed the statute on a permanent basis in December 2020. As Judge Glickman noted, they passed the statute at that time with amendments. They made amendments to the statute. They did not amend the statute to reckon with vaccines, despite the fact that in November 2020, both Pfizer and Moderna had completed their clinical trials and published results from that. And Pfizer, before the council passed its permanent law, was approved for emergency use. And at that point, vaccines were imminently going to become available, not just to the general public, but to the Bureau of Prisons, which was prioritized for vaccine distribution. So the fact that the council was legislating against that backdrop and did not change the statute or say anything to say that vaccines are going to be the end-all be-all factor. Again, that's as amicus in this case, our main point here is that while you can consider vaccines, you have to consider this other information about risk that we know bears on a person's vulnerability to COVID-19. And that's the rule of law that this court should announce.
I know we've taken you over time a little bit, and this will be my last question. Given amicus's interest in sort of the broader view and kind of a lesser interest in Mr. Autry's case and where the trial court might have messed up here, are you aware, is there a pending case before us where you think a trial court has adopted what you ascribe as the government's view, that this is kind of a per se rule, that vaccination means you're outside of eligibility, where the trial court has more, I think I have some doubts about whether or not the trial court ascribed to that view here. Do you think we have a case that's pending somewhere that to your knowledge, a trial court has adopted that sort of bright line, you're vaccinated, you're outside of conceivable compassionate release?
I'm not aware of such a case, which is not to say that it doesn't exist. But I think that's all the more reason to adopt the rule that I'm proposing, which is that vaccines are one among many reasonable factors for a court to consider, because that's the status quo in the Superior Court right now. And trial courts are adjudicating motions under that standard. They're denying a lot of compassionate release motions, but it is still possible to get compassionate release after you've been vaccinated. And so there's every reason to continue that status quo. And I think it's the government that is proposing a different standard, which is that by rule, a vaccinated person cannot get compassionate release unless they fit into this very narrow category of immunocompromised. And I think that's inappropriate. It's inconsistent with this court's holding in Page, and it would be unwise given the state of medical and scientific understanding that we have now of COVID, and particularly in light of how quickly that factual landscape is changing, to enshrine that understanding as a rule of law, as the government is asking, would be a mistake. And so as amicus, we urge.
Well, I have a question for you then. Do you think that if a prisoner comes into court and cannot show that they are immunocompromised, or that the vaccine for some reason will not be effective for them, that in the state, with the state of knowledge we have now, with the statistics we have now, with the advice from CDC we have now, can you think of a situation where such a prisoner would be entitled to release under the statute based solely on saying, I have this, I'm 46 years old or whatever, and I have this serious medical condition that increases my vulnerability to severe medical complications?
Absolutely. And so I'll first just note that, there are so many different factual scenarios and a constellation of risk factors. It is difficult to sort of imagine every single one and rule out that any single one of those scenarios could possibly meet the standard for extraordinary and compelling reasons. But I will just, offer up one scenario. I think if you have somebody who is close to 60, maybe even older than 65, the data that the government points to in its most recent 28K letter shows that people over the age of 65, even after they're fully vaccinated, are dying at about the same rate as unvaccinated people in their 30s and 40s. And that was data from August of this year. If you look at the trend of the data, the website that the government points to shows that data over time. And there was a steady increase in the rate of death among fully vaccinated people at that age, right? And then it just stops in August. But what we know now, what Dr. Fauci just talked about earlier this week, is that there's been a concerning rise in hospitalizations among vaccinated people, right? And so that's what I'm saying. It is difficult to say with certainty what exactly the profile of risk is that's going to meet the extraordinary and compelling standard after full vaccination, because it's changing all the time. And so you could look at a situation where the hospitalizations for fully vaccinated people are increasing due to waning immunity and other factors. You can look at a particular person's circumstance if they are on the older side, if they have several underlying medical conditions, if the rate of vaccination where they're living is low and the rate of community spread is high, if the rate of vaccination amongst the guards at the facility where they're incarcerated is low, and you know that they're going to be exposed on a repeated basis to people who might have COVID. Those are all factors that a trial court in its discretion could determine this person's risk is extraordinary and compelling enough to me that if I find them non-dangerous, and we haven't talked about that yet, but I think that's an important context and backdrop, that we're talking about the risk that is sufficient to release a non-dangerous person. And I think if you look at all of those factors in combination, it is within a trial court's discretion to say that that's extraordinary and compelling. And what I think I'm really urging the court to understand is that it has to be up to the trial court in the first instance, and not this court to pronounce as a general rule of law without even looking at the factual record, trying to hypothesize about what the factual records could be. It's not for this court to make that rule when the council did not see fit to make that rule when it passed this law in December. It's up to the individual case-by-case determinations of the trial court. That's the status quo now, and that's what we believe the rule should be going forward.
Judge Glickman, you're on mute, but I assume you're inviting Mr. Hansford to start.
Good afternoon, and may it please the court, Eric Hansford for the United States. Now that appellant has been vaccinated, he is no longer acutely vulnerable to severe illness or death from COVID, and he is therefore ineligible for compassionate release. We think that result flows directly from this court's decision in Page, and I believe there's now agreement that under Page, vaccination is a proper factor for consideration. And we also think that rule or that finding is consistent with the 6th and 7th Circuit decisions, which said it's an abuse of discretion under the parallel federal statute to grant relief to a vaccinated prisoner absent unusual circumstances, which are not present here. And so I think, in fact, now, at least post-Page, we are not that far from the view of the statute that amicus is proposing. I think now we both agree that vaccination is a proper factor. I think it's notable in Page that this court found, despite CDC comorbidities, that a trial court could exercise its discretion, would not abuse its discretion in denying relief to a prisoner based on a prior infection. Vaccination is providing far stronger protection than a prior infection. And so I think based on Page, it's kind of hard to see how it would be an abuse of discretion to deny relief to a vaccinated prisoner with comorbidities if you can deny relief to a prisoner who has a prior infection.
Yeah, I just want to see if I can drill into what daylight there is between you and amicus. So the way you just articulated it seemed to be in line with the federal circuits, that once vaccinated, there is basically a presumption that there are no extraordinary circumstances, and it would be on the petitioner to show some unusual circumstances, as you put it, to bring them outside of that presumption. I have some resistance to that concept because, you know, what we know about vaccination status could change tomorrow. It might turn out that, you know, once we're 8 months removed from vaccination, it's no longer such a powerful shield against suffering from acute effects of COVID-19. So to create a legal presumption that vaccination just means you're ineligible absent unusual circumstances, well, it might turn out that very usual circumstances, the waning of a vaccination, could put one at an acute risk of more serious effects from COVID-19. So I guess my question for you is, do you disagree with amicus that it would be a mistake to set a legal ruling that vaccination, it would be a mistake to say vaccination, ordinary, you say normally in your brief, you just said absent unusual circumstances. Why don't we just say it's a case-by-case decision, and, you know, we have to evaluate, trial courts need to evaluate the information that they have at the time.
So I think it's not that. So we are not arguing for a legal presumption. I don't think that's what the Sixth and Seventh Circuits are doing either. I think what they're saying is, given the science that we have right now, it is so clear that vaccination provides this sort of strong protection for these common comorbidities like obesity or asthma or hypertension, that it would be an abuse of discretion to find extraordinary and compelling circumstances for someone who's been vaccinated.
So what if, I mean, I'm just curious, because it's kind of an interesting sort of a legal, it's kind of putting in concrete a legal conclusion about the state of scientific evidence that, you know, is somewhat ever changing, and also can just be very different on different records. So let's assume the current state of scientific evidence and knowledge, and that the defense puts on an expert witness that says, you know, for me, for this defendant, the vaccination isn't going to do any good. His comorbidities are just going to break through. And there's just no rebuttal to that. Does that get, you know, and let's assume that the state of scientific literature in the world is contrary to what the defense's expert says. That we know, we see the CDC guidance and it says that expert's full of it. But there's no record about that. What is the trial court to do then? Do they stick to the record evidence, or do they kind of go fishing for what's out in the scientific literature?
So I think that they should be looking at the CDC guidance, because I think that's proper subject for judicial notice. And I think it would be problematic if we were to be trying to have record by record kinds of decisions where everybody is basically talking about the same thing. And I think that's why this is the unusual case where the extraordinary and compelling reasons, which is normally such a case-specific inquiry, actually you can make these kind of broader pronouncements at the appellate level that would normally be unusual, because across the country, and certainly across Superior Court, people every day are litigating this very, very, very common issue. And so that's why it's useful to provide this sort of guidance as to how vaccination figures in, given what we know now, in a way that you normally wouldn't be providing that sort of guidance, I agree, as an appellate court. But my understanding is it's still kind of daily compassionate release requests are coming in, and basically everybody is either vaccinated or is a vaccine refusal case, which of course is not before us. But so I think it's very useful for all of the institutional players here to have some guidance from this court. And I think that's what the Sixth and Seventh Circuits are doing. And just in your hypothetical, where the expert was testifying, the person is not able to benefit from the vaccine. I mean, that is the situation. The Sixth and Seventh Circuits say, maybe the vaccine maybe you are going to be able to be eligible for compassionate release despite receipt of the vaccine. And so then it would just be an individual case. Are you someone who's really not able to benefit from the vaccine in that circumstance or not? But I think,
It sounds, I'll go ahead. I didn't mean to cut you off.
Go ahead, Your Honor.
Well, it sounds like this case, and there are a number of cases like it, involve situations where where the prisoner has a serious medical condition that, if he's unvaccinated, would be sufficient to show a compelling and extraordinary reason to grant relief. And that while he's been vaccinated, in this case, Mr. Autry, we don't have any real hard data that we can rely on as to the effect of that, the effectiveness of that data in protecting someone with Mr. Autry's particular serious medical condition. When I asked earlier, do we have statistical data on on the kind of protection that vaccination provides to persons with various serious medical conditions, the answer I got was we really don't have much. And Mr. Maneri points to evidence indicating that the protection might not be that great, it might wane more quickly, and so on. So Mr. Autry comes into court and he says, look, I have this condition, and yeah, I've been vaccinated, but we don't have good data showing this vaccination really protects me enough. Has he met his burden of proof, in your view?
So I think no, but I'd also disagree with, I do not agree with Mr. Maneri that we do not have data on this. I agree it's not perfect data, but I think we actually have a lot of data indicating that the vaccine is effective for people with comorbidities, which we did cite in the briefing, which is, I'd point to at least three things. There's the Pfizer trial data and the Moderna trial data, which shows equal effectiveness for people with comorbidities and without comorbidities.
Well, of course, I mean, it's one thing to say we can take judicial, or a court can take judicial notice of the CDC's pronouncements. It's another thing to say that the court can just be, reading the newspapers every day and the medical records and the medical journals and so forth, and see that, Pfizer says this and Moderna says that. I don't think I would be inclined to say that a court can take judicial notice of all that and decide accordingly.
This is what the CDC says in approving the vaccine. This is, and we point to that so in other words, we're citing the CDC website. It's also the same information that the trial court cited below in reporting the efficacy overall of the Pfizer. It's part of that, saying there's equal efficacy with and without comorbidities. We also have, I cited to the in our brief, a journal from a peer-reviewed article called Obesity, and that article said there's equal efficacy, or there's every indication there's equal efficacy for people who are normal weight and who are overweight. And then I think we also have the overall numbers, which are very telling here. They're not perfect. I also wish they would break it down by, each specific comorbidity and try to give you a specific possibility of breakthrough infections, but just the magnitude of the reduction of risk, 10 or 15 or 30 times lower hospitalizations and death rates for vaccinated people compared to unvaccinated people, that just necessarily means that vaccinated people with these very common health conditions like obesity or being overweight or being a former smoker, it can't be that those people have the sort of acute vulnerability that unvaccinated people have.
Ms. Walton argued against that a bit when she was saying that, in effect, and I'm paraphrasing and I may not get it right either, the fact that the vaccines are 95% effective for most people is not really saying too much about whether they are or how effective they are for the people with the most serious comorbidities.
I think the Pfizer data and the Moderna data that we cite, which is from the CDC website, which we cite in the MSA, the motion for summary affirmance, is directly addressing that and is saying, yes, in fact, they are the same for people with comorbidities. And so And so I agree there is not perfect data, but there are lots of indications that people with comorbidities are very well protected, which I think is what the Sixth Circuit and Seventh Circuit are recognizing. And then a prisoner can still come in and say, look, I can't benefit from the vaccine in the same way that everybody else can. It's just that the fact that he has these comorbidities is no longer establishing the exceptional and compelling circumstances. And so the other part of the...
So you end up being, your position ends up being very close to that of Mr. Maneri. You both, I mean, you weigh the evidence somewhat differently, but you both agree that in each particular case, the trial judge should consider vaccination, the likelihood that that is protective, and other factors that are positive or that are proved, I guess, that may be relevant. And that's and so this becomes a case-by-case determination in which the quality of the expert testimony, the data, the facts in general will all be considered in the totality of the circumstances assessment. Am I right about that?
I think that's right, except for we think based on the data so far that it's going to be hard in a typical case where someone's only comorbidity, say, is being overweight. It's going to be hard once they're vaccinated to show exceptional and compelling circumstances.
You think a judge can't just wave his hand or her hand and say, well, the data is not perfect. There's some unknowns out there. There's still some risk. And therefore, I'll find a compelling and extraordinary circumstance. You think that would not be sufficient?
That's correct. And I do think that it's important to say, we don't think the standard is you have to show some risk or that you have to show heightened risk. I think the phrase that the statute uses, get in the elderly age, is acute vulnerability. We think acute vulnerability suggests both a comparative look at risks versus other people's, but also it's an absolute look that this has to be rising to the sort of risk that is an extraordinary and compelling circumstance. We think that's the common meaning of acute, that there is some sort of look at whether this matters, not just whether there's a 1% change in risk. So for example, if I have a 1 in a million risk of something and somebody else has a 1 in 2 million risk, I don't think you'd say I have an acute risk because my risk is so low, even if it's comparatively more than someone else, it wouldn't rise to acute. I did want to make just one factual point about the affidavit. Lest there be any doubt, it is entirely clear that it is not considering vaccination. In paragraph 2 of the affidavit, it says that the opinion is formed based on reviewing the following medical records, citing a record dated 2019 and dated 2020, which was before Mr. Autry got vaccinated. And then at the end, paragraph 22, it says, my opinions expressed above are limited to the medical records reviewed and the data outlined above, as well as the current research. So in other words, it's clear that this affidavit from the nurse is not considering vaccination. And what it is instead doing is kind of trying to quantify the unvaccinated risks for the comorbidities that the CDC is recognizing here. And so we do think that in judging this, it's important to keep in mind in looking at the extraordinary and compelling reasons standard to look at the other selected extraordinary and compelling reasons that the statute gives. So it's terminal illness at kind of end of life stages, it's debilitating injury, it's elderly age, meaning you're over 60 and you've served a substantial term in jail, and you have this acute vulnerability to severe illness or death from COVID. And so we think that's telling that it can't be that, we think that informs whether or not you, just by showing you have a 1% higher risk, would be able to make the extraordinary and compelling reasons standard. If I could just briefly address boosters, I think that is very much something that is in flux, as the court recognized. I think the FDA may be approving it for all adults today, or maybe did approve it for all adults today. And this is all kind of subsequent to the en banc determination in this case. But I think where the emphasis has been so far with boosters, it may not stay there, but has been that there's waning immunity in terms of infection, but not necessarily, at least yet, waning immunity in terms of the serious outcomes that we care about, which is hospitalization or death from COVID. And so the higher risk of an infection is not something that's going to get you compassionate release. It's the acute vulnerability to these severe illness or death. And I think you can see that even in the 28K letter from the California jail outbreak that Amicus had cited. It talked about how there was something like 70% lower infections, something like 84% lower symptomatic infections. So in other words, a lot of those infections are just positive tests, not symptomatic. And then I don't think there were breakthrough hospitalizations or deaths noted in the California study. In the Texas case study, there was one breakthrough hospitalization, no breakthrough deaths. So I think that's all indicating that to this point, vaccines are providing powerful relief in this case. We do also think it's
one thing that has bothered me is all these reports about prison guards, prison personnel not being vaccinated, and thereby and still maintaining their jobs, and thereby exposing prisoners to their to risk. Is that a factor that I mean, I find it very troubling that the government wants to that the government is tolerating that, in effect, in an institution where prisoners are, particularly if they're unvaccinated, I guess you'd have to say, exposed to COVID.
So I think BOP guards are now subject to a vaccine mandate. I think they now have to get vaccinated as federal employees. I don't know if there's kind of the current state of potential litigation about that. My understanding is that vaccination rates have gone up of late with prison staff as well as with prisoners. I think the vaccine refusal case that this court ended up not having argued today is kind of indicative that there are a lot of people who initially refused vaccines who are now accepting vaccines. So I think vaccination rates are actually a lot higher now than they were in, say, over the summer within prisons. But I also think in this case, there isn't a claim about the state of vaccination in the defendant's specific prison. So I think that is an entirely proper factor to be considered among the factors for the trial court. I think it's going to be very unusual that that would kind of defeat vaccination, but I think it's a proper factor to be considered.
Okay, thank you. Let us hear from Ms. Walton. You reserved a few minutes in rebuttal.
Yes, thank you, Your Honor. The one thing that hasn't changed is that the CDC lists on its website people with certain medical conditions, 4 of Mr. Autry's medical conditions. Nowhere on that webpage does it say that only people who are unvaccinated with these certain medical conditions are at heightened risk. So it does say vaccines are safe and effective, yes, but it also says the risk of severe COVID-19 increases as the number of underlying medical conditions increases in a person. And the government's contention that people with comorbidities are just as protected as vaccinated people is unfounded by medical data. There's plenty of medical data stating that, for example, people with immunocompromised states are at heightened risk. Well, though the government says that Mr. Autry is an immunocompromised, in fact, he is. He takes corticosteroids, and that is in his medical records. It was mentioned in his pleadings. And this is an example of the problems we have in just pointing to certain quotes from CDC web pages without a really thorough review of the medical records and a person's specific medical conditions.
Was the judge supposed to do that sort of unaided by any expert testimony about how these things interact? I mean, it might be, I think your client has 5 comorbidities. It might be that those are kind of compounding in risk. Once you've got 5, that outweighs the mitigating effect of a vaccine. That might be true for all I know. But there's nothing like that in the record below. So I guess I'm just curious what you think the judge ought to do. Take a stab at it and just guess. Was a hearing requested and denied? Was there more that your client tried to put on that it wasn't able to get in? Because I don't know how else a trial judge is supposed to interpret all this without somebody putting a point on it.
I don't believe that a hearing was requested. Again, there was the affidavit talking about his specific medical conditions. There was the government's 3 pages citing a couple of websites from the CDC about general information about the vaccine in a clinical trial. And then Mr. Autry came back and discussed variants, reinfection, and vaccine hesitancy to discuss about why the vaccine doesn't fully protect him. And then what happened is the trial court cited a couple of websites, one of which says we don't know how long protection lasts for those who are vaccinated. And the other one cites that clinical trial, again, that doesn't apply to Mr. Autry. And based on that, found that he's not eligible. I think the trial court has to really look at the evidence, a person's specific medical conditions, and the evidence put forth from the defendant and the government, and who made their case. Mr. Autry, by a preponderance of the evidence, proved that his medical conditions put him at heightened risk. The government's submission of just totally general information, quoting select pages from the CDC, is not sufficient to defeat the preponderance of the evidence standard. And that's what happened in Mr. Autry's case. He deserves a remand of his case to review all of the evidence of record and to weigh it all and to make a finding after considering all of the evidence, not just the vaccine renders his other extraordinary and compelling reasons for compassionate release immaterial. Thank you.
Judge Glickman, you're on mute.
Okay.
I apologize for that. The case is, I've said, thank you, counsel. The case is now.
I don't mean to interrupt, but I did reserve a couple of minutes for rebuttal if it's all right.
Oh, I don't think I realized that you did that. I apologize. Go ahead, Mr. Maneri.
Thank you, Your Honor. I did just want to briefly address how this court ought to be taking into account the guidance from the CDC, because I think it does demonstrate the daylight between the government's position and ours in this case. So I don't dispute that the CDC is looking at aggregate data and saying at a population level that the vaccines are very effective at preventing hospitalization and death based on what we know now. But I think if you were to pull a random person off of the street and bring them to the CDC director herself and say, what is this one person's risk of falling severely ill or dying from COVID-19? The CDC director would say, well, tell me more about this person. Are they vaccinated? Might be the first question. But the other questions that would follow would surely be, how old are they? What are their medical conditions? Are they living in a congregate setting? How often are they exposed to unvaccinated people who might be carrying COVID with them? Right. And so obviously the CDC can't ask all of those questions for every single person in the country and then provide individualized, tailored risk assessments for everyone and tell them how to go about living their lives. But a trial court evaluating a motion for compassionate release absolutely can and should ask those questions. And litigants can bring information to
Well, wait a minute. Can I stop you for a second? I think all those questions are relevant. I'm persuaded by that proposition. It's when you say the trial court should basically be the interrogator and investigator that that you lose me a little bit. I tend to think that it's the job of counsel, with whatever witnesses and evidence that counsel can marshal, to make the case and present the data and the arguments and the relevant questions and so on and so forth to the court. Because we're not talking about legal questions, we're talking about factual questions and expert factual questions to boot. Do you disagree with that?
No, I don't disagree. And I think my point is merely that when counsel brings those relevant facts to the court's attention, the government would say that the court can't even consider that unless the person is immunocompromised. And that's the very narrow category that the court can consider whether the person is still at risk from COVID. And what I'm saying is the court absolutely has to consider that if a litigant brings forward that information, even if it's information that is not yet part of the CDC generalized guidance. I mean, we've seen from early in the pandemic, litigants were bringing forward credible medical and scientific research about conditions that the CDC didn't have large scale enough data yet. For instance, how COVID interacts with latent tuberculosis. There are several motions brought by people early in the pandemic before the CDC had said anything about that, bringing to light information about the risks there. And I mean, we are still in the past couple of weeks learning more and more like that. For instance, there is an article in The Lancet on October 4th about metabolic conditions and how they interact with COVID-19 that found that not only do conditions like obesity, chronic kidney disease, and diabetes increase a person's chance of falling severely ill from a breakthrough infection after they've been fully vaccinated, but that the relationship actually works the other way, that if somebody gets COVID, it can exacerbate a person's underlying medical conditions. And I want to emphasize that the statute talks about severe medical complications being an extraordinary and compelling reason. It doesn't necessarily have to be hospitalization. We still don't know a whole lot about long COVID. And to issue a rule, as the government is proposing, to foreclose any of those factual distinctions from case by case and from now into the next couple of months, I think would be a real mistake. I see my time is up. I did just want to very briefly address, I think Judge Glickman and Judge Nebaker had both asked about the relative risk between people in prison and outside of prison, and how do we know that somebody being released is going to be safer in the community. I think it is absolutely clear based on the CDC's guidance that people in prison are at higher risk of getting infected. And based on all of the things that I've been talking about, if somebody with some of these medical conditions can bring forward evidence that if they're infected, it's going to result in serious medical complications, that's information that the trial court has to consider. I also think that one distinction between people in congregate settings, in prisons in particular, and the general community is the access to adequate medical care. I mean, we know that people in prisons are not getting state-of-the-art medical care. They might not even get medical attention for days when there are so many people in a facility, particularly in the midst of an outbreak. It might be very hard to get the attention of staff to get the medical care that they need. And finally, Judge Glickman, as you were expressing concern about, there are a lot of unvaccinated staff still in the BOP. I don't know the latest on the litigation or what BOP staffers are doing, but I do know that after President Biden announced the vaccine mandate for federal agencies, the head of the BOP union said that the BOP staff would be resisting that vaccine mandate. So I don't think we can rely on the fact that, surely vaccination rates are going up in the BOP, and that's a good thing, but we can't just treat that as a given. That's still in flux. And that is really, again, I think the main point here is that when there is so much uncertainty, factually, medically, scientifically, it is inappropriate for the court to issue a general rule. And what the court should do is adhere to the holding in Page and to the status quo in the Superior Court, and allow trial courts to consider the most updated evidence on a case-by-case basis and make their determinations that way. Thank you.
Counsel, thank you all. We appreciate your time and your arguments. The case is now submitted, and you may log off.
This honorable court is now adjourned.